guardianship can lead to family conflicts, particularly if there's more than one person that wants to be in charge, or if there's one person that wants to have a professional in charge and one person that wants to take it themselves. So if they disagree as to who's going to be appointed as guardian, feeling they might be left out if they're not in there, these can be prolonged legal battles that take a long time and strain relationships of the family, often disintegrating the family tie, unfortunately. And so we don't want to do it if we don't have to do it, okay? You don't have to do guardianship. Don't. Try to avoid it.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth, pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. I'm an estate planning attorney in Tacoma, Washington. I've been practicing for over 20 years, and my main practice areas include estate planning, probate, and estate administration. On Legacy Talk, we discuss topics surrounding families and estates. Estate planning can often be a confusing and complicated topic, but my goal with this podcast is to make it accessible and understandable to those who need it. So if this is something that interests you, I'd appreciate it if you click the subscribe button and like this episode so that you can follow along as we break down the barriers to estate planning. As always, I'm excited to get to today's topic, and it's timely and interesting. Today's topic is avoiding guardianship, what you need to do or know to protect yourself. Because avoiding a guardianship can be one of the biggest goals of estate planning in order to make sure that your wishes are taken care of and that you're still in control. I had an interesting meeting the other day with some longtime clients, and they had come in to do some updates on their estate plan and asked me about whether their estate plan would protect them against things like guardianships. And I was curious, why would they be wondering about this? That's not a very common topic of discussion. They mentioned watching a documentary on guardianships recently that detailed the corrupt nature of guardianships in Las Vegas. The documentary is called The Guardians and is about the systemic abuse of elderly people in Las Vegas and paints a pretty grim picture of guardianship and its system, at least in Las Vegas. There's another movie on Netflix too that came out a year or so ago, maybe 2 years ago, called I Care a Lot, which is about a professional guardianship who takes over control of people's lives, and in a comedic setting and like a dark comedy, I think. But it's becoming more and more popular of a topic, which is curious to me. I thought it would be a good thing to talk about today. Now, don't get me wrong. Guardianships and conservatorships are legal proceedings that serve a purpose in allowing people to get legal authority to manage incapacitated individuals' financial and medical decisions. Usually, they're close family members that take control of their parents' affairs if they're incapacitated to help them with those types of decisions when they're not able to. And the vast majority of guardianships and conservatorships are perfectly fine and normal. But even though that's the case, they're not all horror stories like this documentary, The Guardians. Even though that's the case, guardianship or conservatorship is still something that you would want to avoid, basically at all costs, I'd say, for yourself and your loved ones. So today we're talking about things that you can do to avoid it, to make sure that your estate plan is designed to last during your lifetime, during your incapacity, and then ultimately when you pass away, thus avoiding guardianship or conservatorship. In order to go through this, we need to start talking about what is guardianship. And so in the state of Washington, there's a guardianship and a conservatorship. And the guardianship is a legal proceeding to get control or authority to make decisions for an incapacitated person's personal medical needs and interests and decisions. A conservatorship in the state of Washington is the same thing for financial dealings. So dealing with paying bills, managing and administering assets, things like that. So you have guardianship for personal, physical, mental, healthcare decisions, conservatorship for financial asset type decisions. And these people, when they're deemed incapacitated by a court, a guardian can be put in place or a conservator can be put in place. Often that person is the same person. There's a guardianship and a conservatorship. It's a joint process typically. Once a guardianship is established, the incapacitated person may lose and often does lose significant control over their personal decisions, including how their money is spent, where they live, even what healthcare preferences that they might have. And the process is time consuming, it's emotionally taxing, and it's all public court proceedings. So why do we want to avoid it? I guess I gave you a couple of reasons just there. Guardianship is a costly proceeding. It involves legal fees, court costs. There's ongoing administration fees, especially if there's a professional guardian. Professional guardianships charge for that work, and so their fees are increased. The guardianship fees would be increased. And when I say guardianship, I'm lumping conservatorship in it as well. So guardianship or conservatorship, if it's a family member, they might not charge you fees. If it's a professional, you're going to get charged fees, which could reduce the value of your estate and whittle away your money. Also, there's a loss of privacy with guardianship. Guardianships are public court cases, proceedings, and so incapacitated persons' medical and financial situation is all laid out in the court paperwork, which is public record, and anybody can see it. There's certain things that they seal that have sensitive information like social security numbers and bank account numbers. But other than that, the general gist of everything, your budget, what you bring in, what you spend out, if you went to the doctor, who your doctor is, what your diagnosis is, that's all public. And so that's invasive to the individual and to the family that may not want that all out on the air. And leading to family or considering family, guardianship can lead to family conflicts, particularly if there's more than one person that wants to be in charge, or if there's one person that wants to have a professional in charge and one person that wants to take it themselves. So if they disagree as to who's going to be appointed as guardian, feeling they might be left out if they're not in there, these can be prolonged legal battles that take a long time and strain relationships of the family, often disintegrating the family tie, unfortunately. And so we don't want to do it if we don't have to do it. Okay? You don't have to do guardianship. Don't. Okay. Try to avoid it. Okay. And so here's some things that we can do to avoid it. First is a very simple document called a durable power of attorney. A durable power of attorney allows you, while you're still functioning fully mentally, you're not incapacitated yet at this point, to create a document that names someone that you trust, an agent or an attorney in fact, to manage your financial affairs and legal affairs if you become incapacitated. The durable means that it's still good if you become or when you become incapacitated. So a durable power of attorney, if you do a power of attorney, make sure that it's durable. If it's not durable, why would you do it anyway? If it's a general power of attorney or a limited power of attorney that becomes invalid upon incapacity, what was the point? There's specific uses for those kinds. I shouldn't say that, but generally when you have a power of attorney in place, you want it to be durable. Okay. And so you want to make sure that thing works if you're incapacitated. And you can give your agent broad powers to make financial decisions, transfer assets, make gifts, create trusts, all kinds of things, change beneficiary designations, things like that that might make it so that they can help you qualify for things like long-term care through Medicaid and other things. In Washington, certain things have to be specifically mentioned in a durable power of attorney or you can't do them. And so you want to make sure that you grant them the ability to manage your affairs in the most effective and efficient way possible. So that's something to consider. And the other thing that you want to do, you want to pick the right agent, right? There's a podcast about picking a fiduciary that we've done. It's probably 20 episodes ago. What you should consider in picking the fiduciary. That's your trustee, that's your power of attorney, that's your executor of your estate. Carefully choose a trustworthy person to serve as your agent. And since they'll have significant control of your assets financially, make sure that they can do that kind of work. Also, make sure that you don't just name one person. It's critical to name a backup. And we'll get into that in a minute. But if your first choice is not available or unwilling to do it, or they have problems themselves, and you don't have a backup, you've got problems. So name a backup agent or attorney in fact. The other kind of document that you should have is a healthcare durable power of attorney and a healthcare directive. A healthcare durable power of attorney is, you guessed it, for healthcare decisions. So a medical healthcare durable power of attorney allows someone to be appointed by you to make medical decisions for you. That means they're talking to your doctors, they're authorizing treatment, they're authorizing administration of medicine, they're able to withhold treatment in certain situations, they're able to look at medical records, Typically, you want to do a HIPAA release in there too, but I'm not going to specifically talk about that so that they can look at your medical records. And without this, there's a guardianship required. If you're incapacitated and can't make medical decisions, the hospital or doctor or healthcare provider will not allow you to help or your kids or friends to make or medical decisions for you without a court order. So that's where guardianship comes in. If you don't have a medical power of attorney and someone appointed as your agent to help with medical decisions or help with financial decisions, the alternative is guardianship. So two simple documents, a financial durable power of attorney and a healthcare durable power of attorney, go a long way in preventing. Because in Washington state, at least, if there's an alternative already available, like a durable power of attorney in place, the court is less likely to say we should have a guardianship here, because most courts don't want to have another case on the docket that's not necessary to be there. And so having a financial and a durable power of attorney for financial decisions and a durable power of attorney for healthcare decisions goes a long way in preventing a guardianship. That's a simple document. They are not expensive. They're simple to make. No reason not to have one. You also want to have a healthcare directive. This isn't as important as on the guardianship side, but a healthcare directive talks about end-of-life care. And it also says certain situations where you want certain things to happen if you're in those types of end-of-life care decision states, I guess I should say. So it ensures that your wishes are followed even if you can't communicate them with the healthcare authorities. So that means durable power of attorney for healthcare will know what to do in certain situations. And a practical tip on both financial and healthcare power of attorneys is talk to the person that you appoint. Discuss your preferences with regard to your healthcare decisions, with regard to your financial decisions with the person that you're naming as your agent so that they know how to carry out your wishes the best, right? It's better to have knowledge from the person that created the document as to what their preferences would be with regard to healthcare decisions or financial decisions before having to make them. Most of the time, it's a spouse or a child or a close friend or a relative that runs those affairs as far as the agent or attorney in fact is concerned, but it's not always that. And it's not always someone that you see all the time. It might be your nephew that lives a state away that you trust and you love, and he loves you, but you don't see him all the time. So you probably want to have a chat if that's who you name. Another alternative, and it's not a replacement of a durable power of attorney or a healthcare durable power of attorney. These things all work together. But another alternative thing that can prevent guardianships is to use a revocable living trust. We could call it a guardianship slayer, potentially. We called it a probate slayer a while ago, a few episodes ago. You should go back and listen to that one if you haven't. It's a good one. So what is a revocable trust? A living trust or a revocable living trust or a revocable trust is a legal entity that you use to hold your assets during your lifetime. You initially create this trust as trustee. You're in charge of it. You retain control of the assets during your lifetime when you're able. But upon your incapacity, a successor trustee who you name and appoint steps in to manage the assets of the trust without having to go to court. Okay? So that avoids court supervision. It operates privately outside of any probate proceeding or guardianship proceeding. By the way, we talk about avoiding probate, right? Guess what guardianship is, essentially? It's probate for someone that's not dead. It's the same essential kind of proceeding, but it's for someone that is alive. The purpose is essentially the same. And if we're trying to avoid probate when we die, we definitely should avoid guardianship or living probate while we're alive. So this trustee can manage your financial affairs in the trust and would be successor trustee immediately if you're not able to make those kinds of decisions. If you're incapacitated, that person can step in immediately without court intervention or approval. Who wants to have to go to court to get approval for personal decisions like this? It's baffling. A revocable trust is also flexible. It's revocable. You can amend it. You can change the assets. You can change the beneficiaries. You can change who the trustees are. You can revoke it anytime during your lifetime as long as you're competent. It's a powerful tool and helps you manage your affairs if you're not able to manage them yourself. So have someone manage them if you can't do it yourself. So we've got the durable power of attorneys, healthcare and financial. We've got a revocable living trust. We should be pretty set, right? Usually yes is the answer to that. Usually if you have those documents, you will avoid a guardianship. Here's the reason that you might not, okay? So these are some things to consider. Once you have your documents in place, how do we make sure that they're still good? Not that they're still good as far as like being effective. They're still effective. But we want to make sure that we're regularly reviewing and updating these documents. Why do we want to review and update these documents? Because sometimes the person that we appoint as durable power of attorney for finance and durable power of attorney for healthcare can no longer serve. Sometimes they die before us. Sometimes they become incapacitated. Sometimes we're estranged from them for some reason, right? For whatever reason, they might not be able to manage those affairs of yours, and they may not want to do it according to your wishes anymore. And so you don't want that kind of person in there. So you want to make sure that the people that you have appointed are still the people that you want, and they're still able to do the job, and they're still someone that you want to have do the job. So you want to review this. This is the baseline, is every 3 to 5 years. I say 2 to 5 probably is better. 2 is better than 3. And after any significant life event, you want to review it. And you want to monitor those who you appoint, because they may have significant life events that make it so that they can't do it, right? And sometimes these laws change. For example, the durable power of attorney statute changed in Washington a couple years ago. It didn't make those old ones invalid, but it made the durable power of attorneys that we create now a little bit different. And so you want to make sure that if you're still able to make an updated one, you probably want to just update it to the new code section so that there's no conflict or no questions, and you have everything right. Okay, that you've reached and meet those new legal requirements. So, like I mentioned, if you neglect to update these, if they're outdated and the trustees or the agents you appoint under for your trust or for your durable powers of attorney are no longer able to serve, or no longer people that you want to have serve, then you've got a guardianship on your hands. And it defeats the purpose of having those documents. It's inevitable that sometimes things happen to people, right? It's inevitable that sometimes the guy that you appoint or the gal that you appoint as your agent or as your trustee may not be able to act, and there's nothing you can do about it, right? There's very little you can do to control that. So here's the solution. You don't want to just name one person, like I mentioned earlier in the show. Don't just name one person. Name a backup. Name two, right? I'd say have at least 3 backups. Once you have a primary and you have at least 2 backups. So you have 3 people that can step in for you. If you're married, maybe you have 4, because you have your spouse oftentimes and maybe 2 or 3 other people, right? Because life is unpredictable, the person that you named as your agent may not be able to act. Something might happen to them tragically. They might move out of the country. They may no longer be able to do it because they have legal problems or something like that. And you may not have time or know even that they've had those issues. So naming competent backups is critical to ensure that there's continuity in decision making. Because if the first guy can't do it, or gal, the second one can step in, right? Or the third sometimes. You want to have multiple successors. Always have a plan B, have a plan C, have a plan D, because you don't want to go to court. And if you know something happened to one of your agents or trustees that you've named, update your documents. The other thing to do is you can appoint co-trustees or co-agents. That doesn't necessarily solve the problem, because you could have alternates that are singular alternates or co-alternates. Sometimes they can act independently. Sometimes they can have to act jointly. If you're worried about it, hey, I don't want just one person making decisions for me, appoint co-agents or co-trustees. Then they have to work together. They balance each other out. As long as they work together well, you don't want to put people that completely conflict, and then you've got totally stagnation and they're going to fight about it. And that might lead to court proceedings to have them removed or changed, or maybe they'll say, well, do a guardianship instead and the court will figure it out. You don't want that. And so if you do name co-agents or co-trustees on documents, make sure they can function together. Another thing you can do to avoid guardianship, and this is not a fail-safe, and it doesn't really avoid guardianship as much as it might avoid a conservatorship, is joint ownership of accounts. You can name, if you had a bank account, you want to make sure someone can manage it if you're gone and you're not married. If you're married, you can have your spouse on there. If you're not married, you can have one of your kids or a friend or a nephew or niece or sister or brother or whatever on those accounts. That might help with financial dealings, but it doesn't help with medical. So joint ownership of accounts doesn't really help on the guardianship side, more on the conservatorship side. And the risk is high too, because like we've talked about before, I'm not a big proponent of joint ownership on accounts or assets with your kids or people that are not you. The reason why is because you're going to have added liability, right? So if something happened to that person that's a co-owner on your account, it's just there for convenience purposes so that they can pay a bill when you pass away or not able to, right? And they get sued by somebody, or they get in a car accident, or they get divorced or something like that, then your asset might be on the hook for paying that judgment, which nobody wants to do, right? So I don't usually recommend it. It's more of a last ditch effort. I don't always recommend it though. Finally, when you're considering this guardianship stuff and your estate planning in general, communication with your loved ones is key. One of the best way to avoid a guardianship is to have these documents in place: the durable power of attorney, the healthcare durable power of attorney, the living trust. That's the best way to avoid guardianship. If for some reason you're not doing those things, this point might make be nonsense. It might make no sense at all. Because how are you going to avoid a contested guardianship? I'm going to talk to my kids so that if I need a guardianship, they know what I need. Why wouldn't you just do your durable power of attorney or healthcare power of attorney to revocable trust? Why wouldn't you just do that? I guess an alternative would be to say, if something happens to me, I want Johnny to be my guardian. That doesn't really make a lot of sense. If you're thinking about it, how about doing the legal work to get it done? It's not that hard. Avoid family conflicts that way. Alternatively, if you have your documents in place, make sure that you tell the people that you've named as guardian or durable power of attorney, healthcare durable power of attorney, trustee, make sure they know that they're that person. And make sure that they have a copy of that document. So if they have to use it in an emergency, they can. Communicate with those people what your wishes are. If you're having discussions with your family or friends about guardianship, you're missing something. You need to talk to these people about how do I prevent guardianship and come see an estate planning attorney like myself. Minimum, do your own stuff online. There's ways to find this stuff online. It's better to have an attorney help you, of course. We've talked about this before too. But at minimum, do a durable power of attorney for healthcare and finance at the bare minimum. If you're thinking about guardianship, think about estate planning. The best way to avoid guardianship is estate planning. And so I guess back to the topic of discussions, I got off my little soapbox there. If you want to reduce disputes among your family, talk to them. Maybe have a family council, right? Hey, I set these documents up. I put Johnny in charge. Sally, don't be sad. I want Johnny to do it because he lives closer to me. I see him more. You've got all these kids to deal with. I don't know, whatever the thing is. And don't make her feel sad, though. Make her feel happy. Make sure Johnny's not going to be a jerk, though. Another thing to do on this is you could write a letter of intent. Sometimes I recommend to my clients to write a letter of intent as to these are my wishes. And as power of attorney in fact, agent, they can make those decisions based on that letter because they have the authority to do so, not because of the letter, but because of the document that gives them the authority, which is the durable power of attorney. You can put a statement of intent or a letter of intent out there too. So I've got a couple stories. That brings us to our story time portion of this episode. Couple stories, okay? The first one is about a client of mine. I think I may have mentioned this in another episode. Married to his wife over 30 years. Second marriage, though, so there was two sets of kids. He had his own kids and she had her own kids. She had dementia that came on. And my client, as the longtime husband, hired me to help with the guardianship because they had no documents in place. No documents in place. They're in their 70s. Nothing. Anyway, we had a great plan. We'd had to get guardianship because nobody could make financial or medical decisions for her. We were going to help get her on long-term care, preserve assets, all kinds of things. But we filed this guardianship, and my client was a gruff guy, and the guardian ad litem who is in charge, or now they're called a court visitor, but the guardian ad litem came in and was a woman, and she didn't like him, and he was gruff and mean, and she didn't like him. And his wife's kids, who lived out of state, of all things too, came in and said, we really want to deal with mom's stuff. And even though all the assets were community assets, there weren't any separate assets. It's ridiculous. Anyway, the guardian ad litem, who makes the recommendation as to who's going to be guardian, recommended the son, who lives out of state, who hadn't had any dealings with the financial affairs of this mother, who had been married to my client for over 30 years. And the court agreed with it. It was contested. We'd fought back and forth, but ultimately my client gave up and said, whatever, I'm not going to get by this. And so the son was appointed. Assets were blown because they didn't plan properly. They didn't consider all their alternatives. And my client, whose wife of 30 years was no longer under his control or even under his purview of what happens with her medical or financial affairs. That's a negative, right? That's a bad story. And it doesn't usually happen. It's very unlikely that if it's a spouse that's competent, appoint or petitions to do a guardianship, that they typically get appointed by the court, especially if there's nothing wrong with them, like this guy. Sometimes personality conflicts, though, can lead to unintended consequences, which is what happened here. So that's a little bit on him, a little bit on the guardian ad litem. I don't know. Another story is I had a client who was in a long-term care facility, a nursing home, and the nursing home didn't like the son who was managing his father's care. I think he was a slow payer on the monthly rent, and they don't like that. They like to get paid, like everybody likes to get paid, right? They've got a right to want to be paid. But they were having difficulty getting paid on time, and the son wasn't around too much. And so they threatened to have a professional guardianship placed over this man who had a son with power of attorney and a trust. And so the son had to intervene. My thought was, and I think I found out at the time, the professional guardian that they used was someone that sort of represents a lot of different people in that facility who didn't have family, right? Which is curious. And I've got nothing against professional guardians. I know a lot of good ones, but sometimes there's the bad apple that sort of poisons the whole bucket. And so in this case, we had to intervene so that that facility would back off, because we've got these documents. There's absolutely no reason why a professional guardianship should be put over this person in order for your bill to be paid. Okay. So the son intervened there. That was a positive story of, hey, these documents work. And then I have one more story. I had a client who had a revocable trust, and I represented her and her daughter. She had a revocable trust, but she didn't have a durable power of attorney. She had one that didn't have an alternate on it. Okay, there was no alternate on the durable power of attorney. The person that was on there was stealing from her, so it was invalidated after that, is what really happened. But she did have a revocable trust, and it was fully funded. So we had to do a guardianship, which is for healthcare decisions, to get healthcare control. But because the other assets were in a revocable trust, we didn't have to do a conservatorship, which made the reporting requirements for the court much simpler. So with a conservatorship, you have to report every 1 to 3 years as to what happens. And in the conservatorship, you have to give a full accounting of all the assets that came in, all the assets that went out, what assets are still available, all of those kinds of things. So it's a big job, and it's not cheap, right? We have to do that every year or 3, depending on the court that orders that. But in this case, we didn't have to report any of the financial dealings because they were all in a revocable trust. So the reporting was much easier. The guardianship, which was just for medical healthcare type decisions, was much cleaner because it was the daughter of the person that was under the incapacity issues. And that was a positive story about a revocable trust coming in addition to the one with the husband in the nursing home. These things work. Revocable trusts avoid guardianship. Durable powers of attorney for finance and healthcare avoid guardianship. And so it's a no-brainer, right? These are not difficult things to do. If you have questions about these, check online, call me. This was a long episode. I had lots of stories. We don't have anything good to talk about in this episode. The something good segment will be bypassed this episode, hopefully to return triumphantly another time. But that brings us to the end. That's it for today's episode of Legacy Talk. I'd like to thank you for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.